Hi there, this is Erica Merrill, and I'm the founder of Perfect Legal Video. And today I am very excited to have our first interview ever with attorney Mark Satawa out of the Detroit area. And he is the owner of a criminal defense firm, and he has got a lot of great information for us today surrounding domestic violence. And I want to welcome you. Thank you so much for joining us.
Thank you for having me, Erica. Hello.
So domestic violence is, it's a very interesting topic, especially when it comes to the law. There's a lot of differences, and I'd love for you to start by just giving us an overview of why domestic violence cases are different.
So, Erica, that's, really in many ways the $64,000 question, because they really are different. I mean, they're not the run-of-the-mill case. A first-time simple domestic violence is a misdemeanor, punishable in Michigan by up to 93 days in jail and a fine. And anyways, the same penalty and consequences as, say, a retail fraud. But they're not retail frauds. They're not reckless drivings. These cases contain a very, very real, definable consequence that many similarly situated misdemeanors do not. They almost kind of fall into, or not almost, but they do kind of fall into the protected, almost politically correct protected class of criminal offenses like drunk driving and sexual assault, where the idea of you're presumed innocent until you're proven guilty beyond a reasonable doubt kind of gets shoved by the wayside, where you're presumed guilty and you almost have to go to court to fight for your innocence, and the bond conditions and the consequences of these arrests initially can be very, very difficult and troubling for many people, and most importantly, professionals.
Oh, yeah. I know we're going to get into a lot of detail on that in just a short while. So can you give us an overview? I know that there's different levels of domestic violence cases, and they're not all so serious, but some of them can be very serious. And so it would be great if you could give us an overview of that before we dig a little deeper.
Sure, and that's a great place to start. So not all domestic violence cases are created equal. First of all, the first thing you have to understand is that domestic violence is a real problem. I mean, there are true battered women, spouses out there who are the victims of what can be this circle of violence, where they are in an abusive relationship and they are being abused. And those cases are serious, and they are prosecuted, and they're prosecuted for a reason. And so those cases certainly exist, and of course they exist quite frequently. But on the other side of that coin, you have these cases where they are often a reaction to a heated argument. Two spouses are yelling at each other and having a difficult evening, and tempers flare, and people get let their temper, their frustration get a hold of them, and one of them, or even frequently sometimes both of them, will call the police and report domestic violence, and the police arrive. We'll talk about that problem in a minute, because way too often, in fact, almost every time in Michigan, a phone call for domestic violence is going to result in an arrest. But before we get there, I can just tell you that simple domestic violence in Michigan is a 93-day misdemeanor. Aggravated domestic violence in Michigan, which is defined as the victim having suffered serious physical injury, and that's the standard kind of focuses on whether the person needed immediate medical attention, not whether they got immediate medical attention, but whether they needed it. That is a 1-year aggravated misdemeanor. So you have simple domestic violence, 93-day misdemeanor; aggravated domestic violence, a 1-year aggravated misdemeanor. The second simple domestic violence becomes an aggravated misdemeanor with a 1-year potential jail sentence. The third domestic violence becomes a felony with a maximum punishment of 5 years. The second aggravated domestic violence is a felony with a possible penalty of 5 years. So these offenses can and are enhanced. It may start small. It may start, not as serious as it could get, but they quickly, mushroom from there and become far more serious.
Wow. I mean, you've given us a lot of information in that last few moments. One of the things that I really picked up on and found astounding, I just want you to confirm what you said. You said that a phone call equals an arrest. Is that right?
I don't know that any police department is going to have a policy written down where you could get a Freedom of Information Act request back and it would state this, but for all intents and purposes, what everyone needs to understand is that a phone call to the police with a complaint of domestic violence is going to result in an arrest well over 95% of the time. I'm sure we could come up with scenarios and situations where there would not be an arrest made, but they are very, very rare. Police show up, they have a complaint of domestic violence, they're going to arrest someone, and that's where your problems begin. Problems with spending the night in jail, bond, etc.
So you're definitely going to jail if they're arresting you, at least for one night. And you mentioned some problems with bonds. I know that there's a lot of areas that you need to cover here, including things like guns and drugs and alcohol and no contact orders. We can start digging into that and make sure that the audience understands the different things that might happen when you get bond. It's not just a get out of jail free card. There's some serious issues that people are facing.
So you're arrested for drunk driving on a Friday night. One of the ways domestic violence is different, as we discussed before, and it is that most of the time when you are arrested by the police for a misdemeanor and taken to the police station and spend the night in jail, you will be given an appearance ticket, something that says you must appear in court within 10 or 14 days, whatever it is, with a court address and a phone number. Domestic violence cases frequently, and again, there's no statistics for this, but far more often than your usual run-of-the-mill misdemeanor, not only do you spend the night in jail the night you're arrested, but they will hold you until you are arraigned. And the reason they do that is because they want a judge or a magistrate to issue a set of bond conditions. Everyone is always worried that this defendant and this complaining witness, sometimes called a victim, is the one that's going to appear on the newspaper the next day where the husband got out, went home and shot his wife or whatever, or really seriously injured her. So everyone is a slave to these bond conditions. And you are, Erica, you are 100% right. I mean, this is where the difficulty really, that gets ratcheted up. You spend the night in jail. Instead of being released Saturday morning, if there's not a judge available to arraign you, maybe you're held Saturday night. If there's not a judge available to arraign you on a Sunday, maybe you're held until Monday, and you're finally arraigned on Monday. So, it's not unheard of to be held for multiple days upon an arrest for a domestic violence. Once you are finally arraigned, the bond conditions are frequently far more serious and far more rigid than your typical misdemeanor. Frequently, you will not be allowed to possess a gun. If you have guns, they're going to be ordered to be removed from your house. Well, that's a problem. It's not a problem just if you're a hunter or a sportsman, but also, quite frankly, if you are a security guard or a police officer or anyone else that has to carry a gun as part of their employment, that's a real problem. I think that most people imagine domestic violence cases frequently occur in the context of drinking. That is actually an assumption held by a lot of judges and magistrates. So even if there's no allegation of drinking in the police report, no evidence that you were drunk when they showed up to arrest you, Frequently, bond conditions will incur you can't drink alcohol. You have to attend AA meetings twice a week, and finally that sometimes even that you're going to have to do drug testing and alcohol testing. You're going to have to submit to random PBTs. All of these things are very difficult restrictions on your liberty. In fact, the gun issue was an infringement on Second Amendment right. And so again, different than the normal case, different than the, hey, you're charged with a misdemeanor, we're going to slap you on the wrist and we'll see you next time. All of these bond conditions can make even being charged with a misdemeanor a really difficult process to go through.
Well, that sounds horrible, especially if it was a false allegation or something happened that night and it was kind of a two-way street and only one person gets arrested. So that's definitely very interesting. What are some of the difficulties with getting the case dismissed? Because you do hear so often that the person that complains about it, they try to drop the case immediately a lot of the time, and they can't.
So I should have mentioned this on the bond condition, but it's a great transition to what you were talking about. The last bond condition and the first difficulty in trying to resolve a case like this is you're always 99.9% of the time you are going to have a no contact provision, which means you are not going to be allowed to have any contact with your significant other or spouse. That means no phone calls, no texting, no emails, no nothing. And you're going to have a no contact provision with your home. Where you live, you're not going to be allowed to return there. And I've had many cases, where not only did the complaining witness do what you said, which is try to call the police and the prosecution and say, hey, look, this was an argument that got out of control. Yes, I called the police. I shouldn't have. That was a mistake. I don't want the case to go forward. I want my husband or my boyfriend to be able to return home. I don't want a no contact order. And I want to drop the charges. I've had judges and prosecutors, in fact, more often than not, with the victim sitting in front of them in a courthouse, refuse to amend that bond order. Well, how are you supposed to talk something like this out? How are you supposed to sort of maybe get to the point where you are moving forward in a relationship without the ability to talk to that person? So that's the first hurdle in resolving a case like this. Again, everyone is afraid. Prosecutors, police, and then ultimately judges are all afraid of this being the case, that if they let it go without a fight, it's going to spiral and become something far more serious. So what happens? Like you said, the complaining witness tells the prosecutor, look, I want the case dismissed. I don't want the case to go forward. The prosecutor will say, okay, but I don't need you. Again, what people have to understand is in a civil case, Erica, if you were to sue me, it's Erica versus Mark, and we're both parties. If you were to call the police on me for domestic violence, Erica is not a party. You are just a witness for the party that charges the case, which is the people of the state of Michigan. The prosecution is the party. You are not. So they're going to start to look at, is there a way to prove the case without Erica's cooperation? And if there is, the case will absolutely proceed forward. And it is not unheard of. In fact, it's very, very common to go to trial on domestic violence cases where the victim is not a witness for the prosecution. In fact, will frequently be a witness for the defense. That puts the victim, the complaining witness, in a very difficult position, because the prosecutor is going to threaten them. They're going to say, did you make a false police report? Because if you get on the witness stand and say Mark didn't do anything, then they will threaten you with charges of perjury or filing a false police report, obstruction of justice. They'll put a lot of pressure on those complaining witnesses to not let this go, to do the right thing. There are victims advocates in these prosecutors' office that work with victims to try to tell them that, look, you have to understand the circle of violence. Maybe you forgive them now, but they're going to be back tomorrow, and they're gonna assault you again. You got to go through with this case. But let's assume, despite all of these protections and safeguards against the victim wanting to give up the case, the victim still refuses to testify and refuses to go forward and wants the case dismissed. The first thing the police are going to do is say, okay, what is it on the 911 tape? Does the 911 tape simply say, please come to my house, there's been a domestic violence? That's probably not helpful enough for the police to prove a case beyond a reasonable doubt. But is there an extended 911 call, like, my husband's beating me right now, and with crying and screaming, and, because those 911 calls will be admitted by the prosecution without the victim's testimony to show the jury or a judge what happened on that evening. There's going to be testimony from the police officers when you got to the house. Were there any injuries? So if we have a 911 call that says my husband just hit me, and the woman has a black eye or a swollen lip or a broken nose, then that is going to be evidence that they will rely upon. Independent witnesses. So was your 16-year-old son home? Did he see what happened? Did the next door neighbor sort of see it spill into the front lawn? Is that person going to be available to testify? If there's independent witnesses of the assault, the police will frequently, and the prosecution will frequently go that route. And finally, and this is the thing that I think most people really struggle with, because it just doesn't sound right, but it's the law. There is an exception to the hearsay rule that says things that are said when you are in an excited, agitated state, like, the police pull up and a woman is on her front porch crying and screaming, my husband just hit me in the face. That is hearsay. A police officer can't testify that Erica told us that when we got to Erica's home. Except in this case, they can, because your statement is considered to be what's called, the law calls, an excited utterance, and that will frequently be used as the evidence to build the case against you. So the prosecution with the police are going to try to see if they can construct a case against the defendant that does not require the complaining witness's cooperation. And if they can, the case will go forward not only without the complaining witness's cooperation, but actually without the complaining witness's approval. So.
Wow, that is really interesting. Can you give me the definition? I think it would be great for the audience to hear the difference between a misdemeanor and a felony at this point.
So again, in Michigan, third, simple domestic violence is a felony. Second, aggravated domestic violence is a felony. Felonies have a much different effect because they control things like your ability to vote, your ability to hold office, your ability to serve on a jury. In Michigan, offenses are considered felonies if they are punishable by, and we have this kind of special brand of offense in Michigan called a high misdemeanor, which is really a felony for all practical purposes. So felonies are anything that are punishable by 2 years or more in prison. So felonies are typically, the distinction between felony and misdemeanor is typically a lot more important in the run-of-the-mill case. But here we are again, domestic violence cases are different. Domestic violence cases are special and unique because, unlike any other misdemeanor, they restrict your ability to own and possess a firearm. Typically in Michigan, a felony conviction makes you ineligible to own and possess a firearm by federal law. Many states, Michigan being one of them, says even a misdemeanor conviction for domestic violence carries that restriction. In other words, a conviction for domestic violence, even a misdemeanor, means that you are not allowed to possess or carry a firearm or own a firearm, which again is is a real problem in many ways.
So domestic violence can be a felony.
The third simple domestic violence and the second aggravated domestic violence is a felony in Michigan.
There are some really important things to know then about your first offense. With all the stuff that we've talked about, and there's a lot to consider. A lot of people will look at their first offense like it's not a big deal, but I'd love for you to give us some of the reasons why it in fact is the biggest deal.
So in addition to what you just said, Erica, there's an even more complicating factor, because in Michigan, we have a special deferment program called 769-4A, and that's just the statute that authorizes this. In domestic violence cases, a first-time offender can be given this special form of probation. And this probation says if the person satisfies all their terms and conditions, and that frequently will be things like, you got to go to batters counseling, you have to maybe do some community service, pay a fine, probably go to something that's called a victims impact panel, where you have to hear about the sort of awful effects that long-term abuse can have. And frequently you'll be looking at a situation where you'll have to get a domestic violence or batterers evaluation, typically by a forensic psychologist that is chosen and hired by the court to tell the court whether you're a person who has a problem and is likely to reoffend down the road. All of those things, but if you do them all, and you complete them successfully, and you'll be on probation for 9, 12, maybe 18 months, and you get all those things done properly, the case against you is dismissed. You don't have a record at all. And people hear that, and it's really tempting. Like, well, sure, I could go and spend a lot of money on a lawyer, and I can fight this, but I have all these things stacked against me. They're going to go after me even if my wife doesn't want them to. And here I have this opportunity to plead guilty under this deferred sentencing program that allows me to just wash my hands of this and be done. I don't even have a criminal record. Why wouldn't I do that? Well, there's some really, really important reasons why. And it starts with this. Once you go down the road of domestic violence convictions, far too often, that first conviction, sure, it sounds like an easy deal. It sounds like a great deal. You walk away from it with no record, but it's there. It's not completely gone. The police know about it. The prosecution knows about it. The next time you're arrested, you're looking at a second offense. The next time after that you're arrested, you're looking at a felony. So not only does your spouse, the complaining witness, have a lot of control over, look, you better, if you don't let me have the kids this weekend, if we're in a custody battle, I'm calling the police and saying that you assaulted me. So that you cede a ton of control to the alleged victim of that domestic violence. But the court and the prosecution, they take an incredible amount of control over your life. The next time you're charged, you don't have that that protection of 769-4A. So frequently, the first charge is a weak case, and that's why the prosecution signs off on 769-4A, and the court grants it to begin with. There's not any visible injuries. They don't have an excited utterance. There is no 911 call. So they're like, look, we'll give them the special probation, and nice and easy, everyone's happy. And then the next time you could have fought that case, you could have won that case. The next time you're arrested, it's a really difficult case to defend. There is a 911 call. There are independent witnesses. There are physical injuries, and you come to a lawyer, and I can't tell you how many times I have people come to my office and say, what really stinks is that first charge was really weak. It was bogus. I just pled guilty because my public defender told me to do it, or I didn't want to hire a lawyer, or I hired a lawyer but didn't want to spend a lot of money, and they told me that this special probation would mean I didn't have a record. It's so common, and my answer to them is going to be, I can't change the past. I can only change the future. You want to fight this case? We're going to fight this case, but this case is a difficult case to defend. This case is a strong case against you. The case you should have defended was the first one. Acquittals, not guilty, dismissals, case dismissed are always better than 769-4A under any circumstances. That doesn't mean the first time someone gets arrested for domestic violence, every case should be fought. Some are appropriately resolved and adjudicated under 769-4A because that's the way they should be handled. But not every case should be handled that way. Many of them should be fought. And the only way to know which camp or side your case is on is to consult with an attorney.
Oh, yeah, no, absolutely. I agree. So, Mark, you have talked about the fact that you're going to lose your guns. They're not going to let you have that. And that's one of the results of getting arrested for domestic violence. Can you tell me about any other fallout that might happen?
One of the other collateral consequences of domestic violence cases is what we in Michigan call a PPO, which is a personal protection order. Some people know them by restraining orders, but what will happen is that victims of domestic violence are frequently counseled by prosecutors and victim advocates to get a restraining order, to get a PPO against the defendant. There are forms, simple forms that basically check boxes, and I'm not making that up. I mean, that really, you sign your name and check which boxes apply to you, and then that goes to the judge, and the judge decides whether or not a ex parte, which means one-sided PPO, gets issued against the defendant. Once again, much like domestic violence cases themselves, PPOs prevent someone from owning or possessing a firearm. They prevent someone from having contact with what's called the petitioner of that PPO, your spouse, your girlfriend, your boyfriend, and they also prevent you from being able to go to certain places, your victim, your spouse's or your significant other's place of work, their business. Sometimes they will even extend to places like their health club or places that they frequent. These PPOs become, again, another complicating factor of wanting to make sure that you address them and understand the kind of impact they have in your life, because it's not a criminal charge. Sometimes they're called quasi-criminal, but they don't lead to a criminal conviction. And so it's important to understand that just because it's not truly criminal doesn't mean it's not important, because PPOs can really, really affect, even ruin people's lives depending on the circumstances.
It sounds like they really can. And I'm glad that people have you to know the law, that have gone to court all the time and have seen these cases and which way they go, and to have someone like you to defend them and give them the right options. I'm really glad that we have you on here today to talk about the great information that you did and help keep people informed during this time. And so thank you again. We hope to see you again soon. And I hope everyone stays safe.
Yeah. Thank you, Erica. You as well. Be healthy, stay safe.